When Dean Traynor appointed me to lead the Human Rights Institute last summer, my very first task, I had just finished my stint as the Drinan chair, he said, and the very first thing I had to do was to identify somebody to step into that role. And Diann had just addressed my seminar students in our final lecture session, and her remarks about the life of an advocate, about the source of her personal commitment to abolition of the death penalty, and her daily practice of sustaining that commitment over the long haul was just so moving and so in tune with my vision for the Human Rights Institute as a center of training and inspiration for the next generation of human rights advocates. I became obsessed with persuading her to join us as the Drinan chair. So lucky for all of us, she said yes. Diann and I came up together as young lawyers in DC in the late 80s and early 90s. We worked just up the hill from here in rundown offices, a few doors down from each other, right across the street from the Supreme Court. And though we worked on different issues, Capitol Hill is actually a pretty small place. So we kept running into each other. Our paths just kept crossing. And every time they did, it was a golden opportunity for me to learn from an exquisitely effective advocate who not only really knew what she was doing, but she was always so gracious about helping the rest of us get better at doing our jobs. Diann has had a truly stellar career as a human rights advocate. For the last 17 years, she led the National Coalition to Abolish the Death Penalty, where she built a nationwide network of state and local organizations seeking to change public policy on the death penalty. And in part due to her persistent and visionary leadership, it was a year ago this week, I think, that Virginia became the 23rd state and the very first state in the South to eliminate capital punishment entirely. Throughout her career, Diann has tackled the intersecting injustices of racism, poverty, and marginalization. Before taking on the leadership post at the National Coalition, Diann spent nearly 20 years at the ACLU, working on a whole range of human rights issues, including criminal justice reform, women's rights, the rights of LGBTQ people, and of course, the death penalty. And prior to joining the ACLU, Diann was a litigator and a public policy advocate at the National Women's Law Center, working to advance the rights of women and girls. Most people think Washington is a town that runs on ego and the power that comes with it. And at some level, of course, that's true. But there's another Washington, one with less ego and a different kind of power. It's populated by people who do the hard and often invisible work of organizing, inspiring, cajoling, and uplifting to bend the arc of history towards justice. And that is where you'll always find Diann. So we are so grateful to you for your decades of work, for your example of moral clarity, for your generosity of spirit, and especially for joining us here at Georgetown as the Drinan Chair in Human Rights. So Diann, as a token of our deep gratitude, we have a couple of gifts for you. One, come on up, is so you'll remember Father Drinan always, as we both do, his book, The Mobilization of Shame. The other is a piece of art I hope you will like, created by Valentino Dixon, a gifted artist who spent 27 years in prison for a murder that he did not commit and was ultimately exonerated in 2018, thanks to the efforts of a team of professors and students at Georgetown. Now, please help me welcome again the Robert F. Drinan Chair in Human Rights, Diann Rust-Tierney.
I'm going to start by saying it's not fair to make your speakers cry beforehand. I'm not going to. I also want to say that I remember our relationship differently. I was always trying to learn from you. I was tracking you down to figure out how you were doing. But I want to thank the Dean taking the time to welcome me here and Professor Marcelino, Elisa, for giving me the opportunity to spend time with you all here at Georgetown. It has been a joy and an honor to be here. I want to thank the students in my seminar for welcoming me here and taking this journey with me on what it means to be a human rights advocate now in these days. I see a number of friends that have come to join me. I want to thank you all for joining us here and hope that you'll have an opportunity to get to know some of the other people here, because I really like to bring together people who are doing great work and get those juices going. I received a number of notes from colleagues remembering Father Drinan, little stories about how he has affected their lives, and just brought those stories up to me as well. So I want to let you know how much of an honor it is to be in a program that is named for him. And I want to lift up his compassion and his spirit and his fierce devotion to human rights as we get into this conversation. I also want to share that I learned just yesterday, I believe, that one of our dear colleagues who has been an advocate for human rights, Robert Rennie Cushing, had recently passed away. He was a legislator in New Hampshire. He was the sponsor of the New Hampshire repeal bill. He led 2 organizations of murder victim family organizations, Murder Victim Families for Human Rights and Murder Victim Families for Reconciliation. And I learned so much from Rennie Cushing. I learned so much about what it meant to have uncompromising commitment to human rights at the toughest time, when your values are most greatly challenged. He was a survivor of homicide. I also learned from him how important it is to let the voices of the people who are affected to speak without your own gloss. He was a fierce advocate for the rights of victims and the right of victims to tell their own story in their own way, and not just be a tactic or a strategy. And so he not only transformed the work from the death penalty, but he transformed the way in which people like me worked against the death penalty. We learned that we didn't need to re-traumatize victims in order to do our work. And so I want to lift his fierce spirit up as well. On December 30th, 1986, the use of canaries in the British coal mine dating back to 1911 came to an end. Canaries were used in the coal mines because of the unique way in which their bodies took in oxygen. It made them kind of a sentient carbon monoxide detector. The birds would show the effect of the harmful gas long before it would have an effect on the miners. And this would give the miners enough time to escape safely. These tiny heroes, against their will, were also used in the US and Canada. Their illness or lack thereof forecasted the health of the larger enterprise. For as long as it has existed, the death penalty has been an unfailing gauge for our nation's moral. Unlike the coal miners, however, we've only lately begun to grasp what that gauge is truly telling us and the true nature of the problem. Unlike the canary, however, which was not intrinsic to the mind, the death penalty has always been tightly interwoven into the fabric of our social, legal, and political systems. For most of my career, I thought the death penalty was a bad thing that needed to end. It's an abomination. It is not who we are. My public appeals to logic and reason and compassion, the reason for that came out of my belief in that. The success that we have had over time dimming the death penalty's shine, convincing state legislatures and the public to reject the practice, lent credence to my thin understanding of the institution. The death penalty is something frozen in time. I would sometimes say it's as if the civil rights movement never came to the death penalty. I would point to the fact that Black defendants had routinely been executed despite the fact that they had been sentenced to death by all white juries where every eligible Black juror had been excluded. I would point to the glaringly lopsided use of the death penalty, where the death penalty was used almost always for white victims and rarely for Black victims. I've come to believe, however, that the death penalty is more than a stubborn relic of the past. It is a predictor of our future unless we pay close attention and gain a better understanding of the two true implications of this hideous practice. The same drivers that threaten our democracy, the fear of a decades-old social and political hierarchy being upended, animate our country's attachment to the death penalty consciously and unconsciously. especially where it remains. The death penalty is more than a bad thing that needs to end. It is evidence of a problem that will continue to threaten our democracy until it is fully addressed. The problem is the failure to recognize, acknowledge, and fully commit to dismantling every aspect of the American caste. The death penalty has played and continues to play a critical role in upholding that system and reinforcing the system's hierarchy in American culture. We cannot fully eliminate one without addressing the other. Now, I'm choosing to use the word caste for the purposes of this discussion. I'm choosing to use the word caste because Isabel Wilkerson used it in her groundbreaking book, Caste, The Origins of Our Discontents, published in 2020. I'm using the word caste not only because she's using that in her analysis and ultimately her analysis of the death penalty, but I'm using it because it's an unfamiliar word used when we talk about American society. And I'm hoping that it will provide us with some distance and spaciousness with which to evaluate the problem. Now, that is not to say that the problem is not one of white supremacy or racism. Isabel Wilkerson says this about race and caste. Caste and race are neither synonymous nor mutually exclusive. They can and do coexist in the same culture and serve to reinforce each other. Race in the United States is the visible agent of the unseen force of caste. Caste is the bone, race the skin. Race is what we can see. The physical traits that have been given arbitrary meaning become the shorthand for who a person is. Caste is the powerful infrastructure that holds each group in its place. Isabel Wilkerson defines caste this way: an artificial construction of fixed and embedded ranking of human value that sets the presumed supremacy of one group against the presumed inferiority of other groups on the basis of ancestry, often immutable traits that would be neutral in the abstract, but are ascribed life and death meaning in a hierarchy favoring the dominant caste whose forebears designed it. The caste system uses rigid, often arbitrary boundaries to keep the ranked groupings apart, distinct from one another, and in their assigned places. The death penalty is part of the scaffolding of the American caste system. The death penalty and the arbitrary and discriminatory way in which it is used is not an unfortunate byproduct. It is foundational to the American caste system. In other words, death penalty is not broken. It is operating exactly as it operates. Isabel Wilkerson traces the origins of the American caste system to the arrival of the first Africans in Virginia. From the very beginning, colonial law created two sets of rules, one for white workers and one for African workers. And she says this became the foundation of the social and political economic system of America. She goes on to describe the myriad of ways in which law and custom normalized the status of the slave and elevated the status of whites according to economic rank and social standing. Legal historian Ariella J. Gross described what she called the unique brand of American slavery this way. For the first time in history, one category of humanity was ruled out of the human race into a separate subgroup that was to remain enslaved generations in perpetuity. But let's look at the death penalty in the context of caste. Isabel Wilkerson makes the direct connection between the death penalty and the American caste system. She says, the caste system instructs us all on whose lives and opinions to bear the most weight and take precedence over any encounter. She calls out the criminal justice system, which she says descends from the criminal slave codes, as one of our teachers. She cites Bryan Stevenson's observation that the greatest predictor of who gets the death penalty in the United States is the race of the victim, rather than just the race of the defendant, which teaches us whose lives are considered expendable and whose lives are considered taxable. Southern states in the pre-Civil War period made explicit distinctions between the criminal conduct of people based on race and the race of the victim. violence against enslaved people by a white person was seen more as a property crime than an offense against the person. The Georgia Criminal Code was representative of the way in which the criminal codes at the time operated. According to the Death Penalty Information Center's report, Enduring Injustice, the persistence of racial discrimination in the U.S. death penalty, which I highly recommend, and on which a lot of the data that I'm sharing with you come. They said this: in Georgia, the criminal code required a death sentence for any murder committed by a slave or free person of color. White people who committed murder could be sentenced to life in prison if the conviction was based on circumstantial evidence or if the jury recommended lenient. The rape of a white woman by a Black person carried a mandatory death sentence, but the same crime committed by a white man carried a term of possibly 2 to 20 years as a prison sentence. The rape of a Black woman would be punished by a fine or imprisonment at the discretion of the racial hierarchy that was enforced historically in the criminal code, including the death penalty, was reinforced by extrajudicial death sentences as well. Lynching, which bore a close relationship to official action, served as another means of enforcing the law of the dominant caste. Now I want to share a story about an event called the Lane Massacre, because it shows the symbiotic relationship between death penalty and lynching. On September 30th, 1919, 100 African-American sharecroppers met at a church in Hoop Spur, Arkansas, under the auspices of Progressive Farmers Household Union. The meeting was one of a number that was being held by Black sharecroppers who were trying to organize to get better prices for their cotton crops, as when they were taking them to market with the white plantation. The Progressive Farmers Household Union stationed armed guards around the outside of the church to keep the meeting from being disrupted. Now, while there's no agreement as to who fired the first shot, shots were fired, and we don't know whether it was the guards or the 3 people who had parked in front of the church, but shots were fired, and W.A. Atkins, a white security officer for the Missouri Pacific Railroad, was killed, and Charles Pratt, a white Phillips County deputy sheriff, was wounded. The next morning, the sheriff sent out a posse to try and round up the people who were responsible. 500 to 1,000 armed white people showed up, mostly from surrounding counties in Arkansas and across the Mississippi. They were coming because they were coming to put down so-called Black insurrection. They encountered little resistance from the Black population in the area, which actually outnumbered the white population by 10 to 1. According to eyewitnesses, hundreds of African Americans were killed as people shot them as they came upon them. And finally, on October 1st, authorities in Phillips County, where Elaine is located in Arkansas, requested U.S. troops come. And Camp Pike troops came. Camp Pike is just outside of Little Rock, Arkansas. They came. They arrived on October 2nd, and the armed people sort of dispersed and went back to their home. The troops rounded up several hundred of African Americans and put them in stockade. The troops were credibly accused also of killing and torturing people because they were trying to find out what they knew about the so-called insurrection. In the end, 285 African Americans were taken from the stockade and jailed in Helena, Arkansas, a jail that, by the way, had space for only 48 people. On October 31st, 1919, Phillips County grand jury charged 122 African Americans with crimes ranging from murder to night riding. Now, ironically, night riding is the crime that was enacted against the Klan's behavior of riding and terrorizing African American agricultural and industrial workers. But nevertheless, those folks were charged with night riding. 12 Black men were the first to go to trial, and they were represented by a lawyer who was appointed by the circuit judge. The lawyer, by his own admission, this will be familiar with the death penalty lawyers, did not interview any witnesses, did not make a motion for change of venue, and didn't challenge a single juror, just accepted 12 jurors that were seated. His clients were predictably convicted of murder and sentenced to die in the election. Another 65 people who had been charged immediately pled guilty to second-degree murder and a sentence of up 21 years just to avoid the death sentence. The NAACP got involved, and after protracted litigation, they succeeded in getting a new trial for half the defendants. The other 6 were finally released January 14, 1925, when then Governor Thomas McRae ordered their release by granting them indefinite furloughs in exchange for guilty pleas to second-degree murder and a sentence of 5 years from the date they were first jailed in the Arkansas State Penitentiary. No white person was prosecuted for the violence in Phillips County, but dozens of Black men accused of killing white people were charged with murder. Public officials actually promised the nascent lynch mob that there would be execution in exchange for not having that kind of violence. The events in Phillips County took place during a period called the Red Summer of 1919, when violence erupted throughout the South, targeting African-American soldiers in particular. But these African-American soldiers came back having had the experience overseas of being full citizens. They came back with that expectation, and they came back to the United States. But those expectations were met with brutal violence. The death penalty and lynching, born of the same purpose of enforcing the rigid status quo of hierarchy, operated on parallel tracks, one reinforcing the other, and teaching whose lives are considered expendable and whose lives are considered effective. The so-called modern death penalty has its legal origins in the slave codes, Black codes, Jim Crow, and customs. The purpose of these laws and customs was to brutally enforce a social, economic, and political hierarchy that posed the interests, concerns, and prerogatives of the dominant caste as supreme, and asserting absolute power and control over the body of Black and brown. So after that, let me give you some heartening news. After more than a century of crime, the Congress finally did pass an anti-lynching bill on March 7, 2022. The legislation is named after Emmett Till, a 14-year-old teenager who was kidnapped and brutally lynched in Mississippi in 1950. So now I want to talk about the death penalty today. But before I do that, I want to read a quote from James Baldwin. I'm one that says there's always a quote. James Baldwin, you should just keep him in your pocket. He's got a quote for everything. And I wake up and wish here. I want to hear what he has to say. But here's what he has to say about history. History, as nearly no one seems to know, is not merely something to be read, and it does not refer merely or even principally to the past. On the contrary, the great force of history comes from the fact that we carry it within us, are unconsciously controlled by it in many ways, and history is literally present in all we do. So the death penalty today, the good news is the death penalty continues to be in decline. About half of all the states have either abolished the death penalty, never had it, or have moratoriums in place that were imposed by their government. 2021, again, was the 7th consecutive year in which states conducted fewer than 30 executions and imposed fewer than 50 new deaths. As of October 1st, 2021, there were over 2,000 people on death row, approximately 2,450. The majority of defendants sentenced to death in 2021 were people of color. 6 were Black, 4 were Latino. More than 3/4 of the cases, 14, involved at least one white victim, and 13 involved only white victims. 5 of the 6 death sentences imposed on Black defendants were for interracial murder, 4 involving only white victims. 3 of the 4 death sentences imposed on Latinx defendants involved interracial killing. No white defendant was sentenced to death for any murder that did not involve at least one white victim. So to the extent that the death penalty is supposed to have something to do with public safety and be a response to homicide, here's what we know about homicide. Homicides tend to be committed by young men, and the victims of homicide tend to be young. Most homicides occur within the same race. White people kill white people, Black people kill Black people. The number of Black and white homicide offenders and victims are roughly similar, although Blacks make up a smaller share of the population. Women commit relatively few homicides and are a small minority of homicide victims. Who doesn't get the death? White killers of Black victims, almost never. Crimes in most jurisdictions, almost never. Those who are sentenced to death are being sentenced to death in a very select few set of jurisdictions. The worst criminals are not those who committing the most heinous crimes are not those who are getting the death penalty at higher rate. And in fact, even among those sentenced to death, over 70% see their death sentence reversed. That means in over 70% of the cases, a judge decides this is not a death-worthy case. This is not a case. There's an error. This is not a case where the death penalty should be applied. And even among those with a signed death warrant setting a date of their execution, more of these are stopped than are carried out. Researchers have studied the death penalty and the way it's used over multiple years, over multiple jurisdictions, and they have uniformly come up with the conclusion that the death penalty is used overwhelmingly in a racially biased way, racially biased pattern. Most studies have found that the race of the victim is likely to affect whether the death penalty is charged, whether their sentence is ultimately given, and especially when the defendant is African American and the victim is white. So, from my perspective, the death penalty is completely disconnected from a legitimate, safe public safety purpose. Why? It's not targeted or aligned where public safety concerns are occurring. If it were, we would see an even distribution of death sentences and executions across victims and across defendants. There's no evidence that the death penalty has any impact on preventing crime. And in fact, proponents of the death penalty have given up on the argument of deterrence many, many years ago. They couldn't come up with any empirical evidence, and they've fallen back to this argument about, well, we need to have the death penalty retributive. We need to send a message. Well, indeed. The way in which the death penalty is used today hasn't changed much from the way in which it was used historically, when the intention was explicit to delineate the relative value of humans based on race, and to some extent social. So why does it matter whether we understand the death penalty is more than a bad thing that needs to end, or whether it serves as a pillar of the American caste system? I think it matters because it informs our strategies and tactics for ending the death penalty and the alliances that we make. How we win is as important as that. It's the difference between short-term gains premised on reinforcing the norms and rules of the caste system and long-term victories that end the death penalty and dismantle the power structure of the American caste. It's important because it acknowledges the true threat to our democracy, the continued existence of the American caste. Why? Because the ideology of caste is motivating a sizable segment of the country to embrace autocracy and anti-democratic models of governance if it means maintaining their place in the racial and social hierarchy. We must affirmatively and skillfully make the case for universal human rights and teach and demonstrate that expanding human rights is not a zero-sum game. Fundamentally, the American caste system that we have is inconsistent with our aspirations for a truly diverse and representative democracy. The so-called divisions experienced today are the direct result of a segment of the population not being on board and comfortable with diverse and representative democracy and what it literally looks like. These divisions are deeply rooted in our history, collective ancestral experience. Let's take another look back at history to see the response of the participation of African Americans in the political process and the prospect of power sharing during Reconstruction. Daniel Byman describes this in his article, White Supremacy, Terrorism, and the Failure of Reconstruction in the United States. He first describes the remarkable progress that was made during Reconstruction. He writes, during Reconstruction, 17 Black Americans served in the US Congress, more than 600 in state legislatures, and hundreds more in local offices throughout the South. Voters in Alabama, Florida, Georgia, Louisiana, Mississippi, North Carolina, and South Carolina all elected Black leaders to national office. The response to this progress was a reign of terror that would decimate these numbers. It would take almost 100 years for Senator Edward Brooks would be elected to the U.S. Senate in 1967, making the return of an African-American leader to that. Here is his description of the level of political violence brought to bear against proponents of democracy. Throughout this period, violence plagued the South, though comprehensive figures are lacking. Snapshots of different states at different times are painfully suggestive. In Louisiana alone, a congressional report found that white supremacists had killed more than 1,000 people, mostly Black Louisianans, between the April and November 1868 election, and that they had killed or wounded 2,000 more in the weeks before the 1871 election. In Arkansas, white supremacists killed more than 2,000 people in connection with the 1868 presidential election. And these talks about how the laws were changed. In 1865 and 1866, Southern states enacted the so-called Black Code, which aimed to ensure racial control in the absence of slavery. The specifics varied by state, but they included measures that denied Black residents the vote and other rights, including sitting on juries judging white people, owning firearms, and exercising the right to reject contracts. Some states even refused to ratify the 13th Amendment officially. Mississippi would not ratify the 13th Amendment in 1995. And then it was the 13th Amendment was only actually officially ratified by Mississippi on February 7th, 2013, when they finally sent the paperwork to U.S. Archives. Daniel Byman argues that Reconstruction failed to deliver on its promise of representative democracy because the federal government did not take a concerted and consistent approach to addressing the discriminatory legislative efforts and the unrelenting violence by those opposed to full participatory citizenship of African Americans. He characterizes the response as unclear and vacillating in its commitment to stand, in his words, white supremacy for our purposes past. So where are we today? There are two African Americans in the Senate, Senators Cory Booker and Senator Tim Scott. There are 58 African Americans in the House of Representatives. And according to the Pew Research Center, I think just came out with this data, white Americans make up a larger share of Congress than the US population. In other words, the share of the US population, white Americans, is 60%. And the white American share in the Congress is 77%. As demographics in the United States have changed, these old unresolved tensions have escalated as some become concerned that the tidy framework keeping the peace and the status quo of power and wealth is again in jeopardy. In 2008, when the first African-American president was elected, for some, the foundation of settled expectations crumbled. We have seen a troubling return to and calls for and threats of violence against elected officials and people of color, especially where people of color are numerically in the majority or comprise a significant segment of voting. These calls to violence based on the illegitimacy of votes from Black, Brown, and Indigenous people culminated in a violent attack on the U.S. Capitol, where the Confederate flag was taken into the Capitol for the first time. We saw people calling for the capture and execution of public officials who dared to allow those votes, Black and Brown and Indigenous voters, to stand. According to the NAACP Legal Defense Fund, since the 2020 election, these 17 states passed voter suppression laws with over 400 similar bills introduced in 49 states. Florida, Georgia, and Arizona just recently are considering legislation to create new law enforcement agencies to pursue voter fraud allegations. If we are to save and protect our democracy, we must understand the degree to which the threat to democracy is the desire to protect the status quo of the American. If we're going to finally end the death penalty, we must understand its role in reinforcing and teaching the rules and norms of the American. We must acknowledge that it cannot be fully eliminated, the death penalty or the caste system, until we denormalize, deconstruct the caste system it was designed to protect. Why is this important? This informs our role as lawyers. Are we always the smartest people in the room? Is it always the tactics of litigation that inform our strategy and tactics? Is it always the tactics of litigation that inform our public discourse? Is our role to enhance and amplify the voices of the people who are most affected by the problem? Now, this is not to say that we should stop all the tactics and strategies that we've used and successfully so far: litigation, public education, strategic communications. And we are right to take every opportunity to make policy changes and inroads into the practice. But lasting change, and change that does not come at the expense of other reforms, such as ending extraordinary sentences, reducing the carceral state, and changing our prison system from one that imposes systematic abuse and trauma on to one that heals, repairs, and rehabilitates. We can't get to those things until we get to the heart of the problem. And the problem is a system that ranks and devalues people based on their race and ultimately views all humans as disposable. We can't rely on the narrow path of the law to make fundamental changes and advances in human rights. We are looking for deep, transformative, social, cultural, and political change, literally an evolution in humanity. We can make a great deal of progress through legal reform, but we must remember that the law is a reflection of cultural norms and systems that must be fundamentally addressed. We must provide lawyers seeking to advance civil and human rights with additional and new tools: knowledge and understanding and appreciation of history, how we got here, knowledge and understanding of the experience of a broad range of people in our country, and indeed the world, knowledge and understanding of how narrative and storytelling affect our work, knowledge and understanding of strategic communications, organizing, coalition building, and power building, knowledge and understanding of the importance of research on human behavior, psychology, anthropology, the mechanics of culture change, and how they might inform our strategy and tactics. I don't have all the answers. I have a lot of questions, but not all the answers. I have some ideas about a couple of things we should do. I think we need to invest in economic security that reaches all segments of American society and make robust efforts to change the cultural narrative that makes rights and progress a zero-sum game, to expose the lie that economic and political progress for some is a threat to economic progress and survival for others. We need a compassionate, thoughtful, thorough public discussion about the caste system, white supremacy normatives, and why this system is a cage for everyone involved. We need to mobilize all sectors of society to transform the ways in which we see ourselves, we see each other in society. And we must not make the mistake that was made during Reconstruction. We have to have a robust response to political violence that is keeping us from actually fulfilling the goal through democracy. Why does it matter to the broader struggle for human rights? Because if we end the death penalty solely on the basis of cost, or it's too hard to get right, we might win this particular incursion into human rights, but we'll be back here again until we win the day on value. And the values are that human rights cannot be compromised, pragmatized, strategized, or monetized away. There is no national interest that is more important than a universal standard of human rights. And indeed, our national interest may depend on a universal standard of human rights. We are in a global struggle and the fight of our lives for democracy in the United States and abroad. And that is because autocrats and tyrants have taken our business-like pragmatism as we need to come together in all parts of the world No more first among equals around a common set of human rights values. Indeed, we already have. But we must insist that these values be met home, domestically, and be met abroad in all of our interactions with all of our world leaders. No. So much of what I see at Georgetown Law Center is encouraging. I see this in the expansive vision of what it means to be a human rights lawyer in the work of the Human Rights Institute and the students who participate in the program. Beyond the Human Rights Institute, I see it in the vision of the practice centers, in the clinics of law school, and so many of the faculty and administration. Among the best equipped lawyers for the work ahead to advance and expand human rights will be the lawyers forged here. Through a rigorous approach to an understanding of the law, a broad and informed understanding of the world and society, a healthy dose of humility, and a skill set that will allow them to make transformative change. Let us commit to a wholeheartedly uncompromising vision of human rights, one that recognizes that the status quo makes true human and civil rights impossible to live. We must expose and dismantle the ubiquitous and yet invisible American caste system. We must take it down, and in so doing, end its fearsome enforcer and cruel instructor, capital punishment.
Just putting the death penalty in context of the broader struggle is really revelatory. So thank you for all of those reflections. I have so many thoughts and questions that I wrote down while I was listening, but I already had my chance to speak. So I'm going to start with you all. And Olivia, do we need to have mics for the... Yeah, so I guess in order to get this all on the recording, we're going to ask you to speak into a mic with your question. I know you must have some. Okay, use this one.
Thank you so much, and apologies for showing late for the beginning of your presentation. Inspiring, of course, lots of questions, and something I actually struggle a lot with on my daily work and reflecting on my work, because I of course, I will fully agree with you. The question is, how do we bring to the conversation those that don't agree with us, that don't agree with you, and with your proposition? Because this is one of the biggest challenges of our time. We're living in a highly polarized environment. So to change the narrative, how do we do that? Because all of us, we all agree on the same principles and values. But in order to advance transformational change in such an important issue that is continues damaging the American society so profoundly, in many ways. So what would you recommend? What are your reflections and your... Yeah, so it's a big question. So thank you.
Thanks. On the question of caste, I don't think we know yet. I think we're just at the point of naming the problem, and so we're talking about caste. We're hearing more people talk about white supremacy, so we're naming it. But I think that, and I don't know whether there's been any other area where we've had to do this really kind of transform it, really change how our brains actually almost work. And so I think part of what I would want to do would be to really study why we think these. I think naming is important, unpacking these things, because I think so much of it's unconscious. So I think constantly saying, why did I do that? Oh, I'm just in reflexive caste, So I think it's part of it is that there are groups like the Frameworks Institute that actually study how people think and how you move people from one point. So I think part of it's like naming it, studying it, and then we've never had sort of a comprehensive campaign to actually change the way people think about certain things. But it's a really hard problem to think about, because so much of how we think about who we are and what we are is informed by that caste system. And so it's a long effort. on a shorter question, smaller issue, not smaller issue, but on the shorter term, like the death penalty, what we found to be successful is to get people focused on the things we can agree on. We can agree that we ought to not wait until something horrible happens, but we ought to be investing in things ahead of time. So if we actually do invest in the things that reduce crime, there's agreement. And we actually were having this conversation in our class that, part of our work, if we actually just work on the things that we know will work, get people better housing, get people more economic security, get people better treatment for trauma. If we actually have an impact on the things that are creating crime, it creates a different environment. So it is a long-term, as I said, that's why I said it's an evolution. We have to be different kinds of people than we've imagined, but we have to figure out how we're going to get there.
So I'm glad that you mentioned kind of the continuum of prison abolition and de-incarceration to the death penalty. But very often when there's a victory in the death penalty, it's commuting it to a life sentence. So I was shocked, right, from my American perspective when I found out that murders might draw a maximum 15 to 18-year sentence in other countries. So how do we start kind of changing our ideas about what the worst punishment should be and recognizing that even life terms are not a victory?
Right, and that's a real challenge, and it's one, as you pointed out, that has been a real struggle within the death penalty movement, and some of it is sort of also our strong roots in the litigation. So if you're litigating a death penalty case and your client doesn't get a death sentence and gets life, you're celebrating, and so much of that is because of the draconian nature of the crime. So much of that trade-off comes from that. I think when it comes to sort of policy, that's something that I've always been really concerned about. I think one way of avoiding it is for us as advocates against the death penalty and us as advocates for other criminal justice reforms to come together to be in the same room, so that we and to build this sense of like common vision. And so it's working in less siloed places. And in fact, the Ford Foundation actually brought together, we were part of that, a big group of criminal justice advocates from across the country to figure out whether there isn't some huge umbrella frame that we could come under with messaging so that we weren't bumping into each other. Because it's not just death penalty versus life without parole, it's nonviolent offenders versus violent offenders. It's a whole range of things. And so there was some effort to do that. So I think it's having that vision. I also think it's about some of the reason that you make these trade-offs is because you're sort of dealing with the hand that you've been dealt. And for a very long time, I thought that was my job. And I think a lot of that comes from, the fact that most of this work is done by nonprofits that don't really play in the political space. And so in the space where you're dealing with the legislatures that you end up speaking their language and you do the trade-offs. I've come to believe that a critical part of the work has got to be changing the decision maker. And so I feel like part of the way to get to this is to make sure that more people with progressive values, more people who have our values are elected at every level. And then you're having a different conversation. So first, I think it's a consciousness that none of us can win unless all of us win, and understand there's a through line in all of these human rights struggles. It is figuring out whether there's a message, an umbrella message that we can all agree on, that we can carry forward so we're not bumping into each other. And then ultimately it's changing the decision maker.
Never shy. Thank you so much for that talk. That was terrific. And I have probably a very obvious question that I'm sure you get all the time, but that might be particularly of interest to the students, but I think to all of us. Can you talk about your own career trajectory? How did you end up where you are? What were the things that you did at different stages in your life that led you here? Whether it was a plan or not a plan, that would be love to hear about that.
Sure. I felt drawn to this work. I was actually wanting to do something else in high school. I wanted to be an actor, and I thought I was going to move to New York and be in the theater. As many lawyers or secret actors. It's not too late. well, not really, I've got one credit, but anyway, we won't talk about it. But during that period of time, I actually looked at us backstage doing all the things and thinking, boy, if everybody could work together on other things, maybe it would make a difference. And so by this time I graduated, I had pretty much decided that I had been fortunate to have a great education. And so I wanted to really use it for working on civil rights. And I originally said, well, wherever I'm placed is where I'll do the work, because God knows there's enough work to do. So I started out at the National Women's Law Center. Well, my first job right after law school was working for an organization called Legal Counsel for the Elderly, which was a legal services corporations program that helped low-income DC residents. And I loved it. You know, I was keeping people's lights on. I was getting people their Social Security. The office was this cocoon of like loving people. And then the National Women's Law Center offered me a position, and I had to make a hard choice about whether or not I wanted to have more impact, or whether I wanted to continue to do. And I, to this day, it's still a hard choice, because it feels really good to help people in one-on-one, but I wanted to make a bigger difference on impact. And so I went to the National Women's Law Center, learned a lot from them, but was also always felt that the death penalty was wrong. And so somehow I got involved in this volunteer group that had a phone tree at the time. And every time there was an execution, they would do the phone tree, and we'd stand in front of the Supreme Court, literally in the middle of the night with a sign. And I remember, like, I'm doing this because I hate the death penalty, but I really hate being here at midnight with nobody looking at me. Can't we get a little ahead of this? And so one of the people who came to one of the vigils was a woman who worked at the American Civil Liberties Union. Fast forward, she ends up leaving, encouraging me to apply for a position there. And I applied and said, by the way, can I work on the death penalty? And they looked around and said, nobody's standing in line to do that. So they, that's how I started on that. And so I just, I felt called to do it, and as people here know, sometimes you wish you weren't called to do it. But I just felt called to do it. And so I worked at the ACLU doing the federal legislative work, where our main goal was like the symbolic fight to keep the death penalty from being reinstated at the federal level. We then finally moved on to the National Coalition to Abolish the Death Penalty, where after we sort of saw that the real fight was going to be state by state changing the policy. And as strong as the ACLU is to do that, they're a multi-issue organization. And if you really want to focus, you need to go. So that's how I was there. And then kept in touch with Elisa, and I'm here, and I love it here. So that's kind of how I got here. But I guess in terms of, preparation, I just think that you have to be, do the thing that you love, do the thing that you have the passion for. I have to say, we were laughing about how long I'd been at the ACLU. I lived from Congress to Congress, which is 2-year increments, but I love the work. And so the time went fast. So always do your passion. There's plenty of work to do, but follow your passion.
Thank you so much. I'm curious about what you think about how we should study the law given our caste system. I'm in Curriculum B, and in Democracy and Coercion, we've been talking about the Fourth Amendment, and we sort of inevitably end up having these long conversations about whether the officer had reasonable suspicion or probable cause, and questions have been raised about whether learning that doctrine sort of inevitably boxes us into kind of not having the conversation that we should be having, given what you talked about today. And so I'm curious what you think of that.
Well, I think you have to learn the rules. And I think what you because that's what we're working with. When I was working for the ACLU, one of the things that we prided ourselves on, I prided myself on, was like, I tried to learn the congressional rules backwards and forward, because whatever your policy outcome is, the understanding the rules is the difference between victory and defeat. And so I think that you're kind of coming to these things now with not a dual consciousness, sort of a understanding, like, this is what I'm working with, and so I'm going to understand how to do this. So but I can also still have a critique of how this is working. And that critique can inform maybe the policy changes that you want to get. So I don't think it's like, this is all like the work of the white supremacists. I don't think you're rejecting it that way. You have to understand the rules, because these are the rules we're working with. but that added understanding talks about where, maybe gives you ideas about where to push, maybe gives you ideas about where the law can be pushed. And so I think you're 100% better off than somebody who's just taking it at face value. You now see it for what it is, can work within that confines, but also know where we need to be changing things. So I hope that helps.
I want to pick up on your career advice to law students who are interested broadly in the racial caste system and specifically in changing the criminal justice system. Mm-hmm. If somebody comes to you and says, "What's the cutting edge issue now? Is it death penalty abolition? Is it shortening prison sentences? Is it decarceration? Where should I put my energy? What kind of career should I look for? Should I be, if I'm working to abolish LWOP, am I undercutting my colleagues who are working to end the death penalty? So where would you tell people to put their energies now?
Well, there are also people in this room who should probably also answer that question. So I'm gonna start, and then anybody else who wants to pick up. Well, first of all, I think that and you're using different strategies too, right? I think that one good place to start would be in reducing the carceral state. Just that mentality that our response to everything, whether you get your children vaccinated, or whether you pay is incarceration. And so it seems like that's a good place to tackle, and you can tackle it from a lot of different ways, either from, in the context of specific policy areas, making sure that that's not the remedy, to helping people think about other ways of addressing problems. There was, for a while, I haven't heard much about it lately, this whole push to talk about crime and violence and murder as a public health issue. And that has sort of, in some ways, I haven't heard as much about it, revising that. So I feel like addressing that big picture of the carceral state is one. I don't think that, working against life without parole is inconsistent with ending the death penalty, if we do it right. Because the kinds of motivations for life without parole are also carry through to the death penalty. This idea that people can be thrown away. So that's one. But I think we have to talk to each other, and I think we have to ourselves get out of this zero-sum game idea. Like we got to get the death penalty done first, and then we're going to come back for you in life without parole. I mean, when Bryan Stevenson argued the case about juveniles being facing life without parole, that didn't stop us from ending the death penalty when he won. And so I feel like that each time we get to that consciousness about like who a human being is, the fact that people have said we're more than the worst thing we've ever done. That consciousness helps all of these issues. But I think we've got to get out of the siloed way of working. And like my issue is worse than your issue, and I think we've got to come together. But I would say that attacking that carceral state mentality would have a ripple effect if we have the right consistent messaging. But other people may have other thoughts.
Great talk. I'm glad I came. I'm a real estate attorney. I was interested in specifically as you talked about different disciplines, because part of this is space. Mm-hmm. Part of this is who builds the space. Part of this is who understands who builds the space. It's all related, mm-hmm. and you don't hear it. So right. This is interesting.
That's right. I'll never forget there's a study years ago about violence that was a study of mice, and the study had mice that were in a very contained area with very little space, and the rate of like mice attacking each other and biting each other was directly related to the amount of space. The same kind of mice in a different space engage differently. So I think that's about space. It goes to the segregated nation of our society, and that's something we're still working with, as you know.
Wow, don't you get any questions, Lucy?
Oh, she's gonna.
Yes, you do. I'll take one, then you go. So, I mean, the question I'm going to ask, Diann, you could do a lecture on, but I just want you, I would love to hear your reflections, given the pivot you're making, right? Try to find approaches to a new challenge, a really very difficult one. If you could reflect a little bit on the sort of strategies and approaches that you found most successful, not the substantive arguments about ending the death penalty, but the strategies and any learning you have had for all that experience that you think will be helpful moving forward. That too might be helpful to our students
I think
to
so.
hear a little bit about.
I think, we touched on a little bit. It's, talking to people where they are and starting where there's room for agreement. And one of the places that we found that was around issues like, ironically, race and the death penalty, and when we were trying for years to pass the Racial Justice Act. And so part of the reason for doing that was a pivot from me trying to convince you straight on that the death penalty is wrong. Because I used to talk about it as when I'd be talking to somebody about the death penalty, they'd be looking at me like this. But then when I started talking to them about, well, we can all agree that the death penalty shouldn't be applied this way. Or we can all agree, you would see them open up. So I think that finding, trying to start from a place of common values and also engaging people in problem solving. One of the things we also found was whether or not we passed the Racial Justice Act, the fact that we were having the conversation in the context of trying to pass actual legislation, and people were actually trying to do the work, that actually had a greater impact on people because you literally, you're showing them, learning by doing. And so I feel like starting where people are, where we see consistently, there is a general, notwithstanding all the kind of crosswinds, there's a general acceptance of fairness, and we all want to be fair. I think another really encouraging spot is where people agree on, as I said, the root causes of crime. Let's invest in the right things. So I think, remembering as an advocate that you always have to figure out where your people are and start from where they are, not repeating the bad information they have, but trying to speak to the values that you share with that person as a lead. I think that was the thing that was most helpful for me.
Okay, I will ask one last question because you mentioned storytelling and the power of narrative, and it's something that I've been thinking a lot about myself. We launched this Storytelling for Social Change film series, and you're a creative person. You're a dancer. You're an actor. You think a lot about this. What do you think is the role of the creative spirit in advancing social change?
I think it's huge. There was a time when I thought my little memos at the ACLU were going to carry the day, and they didn't. What it carries the day are in the same way that books do, when people have a lived experience through film, books. And so I feel there's much more we can do. And thinking about how we change this vision, which is so hard about caste, I think there is a huge role for film and television to do that. And more organizations are investing in what they call culture change. And so getting more screenplays about our issue. I mean, Dead Man Walking, that was written by Sister Helen Prejean as a book that became a movie, that changed a whole generation. I think when at the beginning of my class, I asked people to bring in something that was important to them about why they were in the class. I think like 4 people in the class had read Bryan Stevenson's book, Just Mercy, and then the film. And you're seeing films like, and that has a ripple effect. Warner Brothers Films, which made that movie, made a real investment in making sure that it was more than a movie. And so all of their rollout about it made sure it got into every corner of American culture. I remember Michael B. Jordan, before one of the big basketball games, I can't remember one, showed it to the team, and so that's going to have a big effect. So I feel like that's something where we really have a lot of potential because look at what Ava DuVernay is able to do with 13 and the book the movie When They See Us. That's the future, and making sure that we're connected to that. And we're prepared to take advantage of the lift that it gives us. So I'm a huge believer in the importance of culture because we're changing culture, not just the law. So I'm a huge believer in that.
Well, this has been an incredibly rich conversation. Thank you so much. And it's been a wonderful time having you at Georgetown. And I encourage those of you who haven't yet to stick around and have a conversation with Diann. There are refreshments outside these doors, and I hope you'll join us. Thanks again.
Thank you.